Welcome to Season 5, Episode 12 of Fire Away, Rudner Law's online show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator. I'm the founder of Rudner Law and your host of this episode of Fire Away. Fire Away streams live online every month, and if you missed an episode or if you want to watch one again, they're always available on our YouTube channel. Please subscribe, our Facebook page, and on our website. Today, I'm very excited to be joined by Frank Newman and Brian Epstein of Newman HR. We are going to be talking about downsizing and layoffs and discussing how to navigate those situations safely as an employer to limit your risks. So Frank, Brian, thank you so much for joining me today.
Great. It's our pleasure to be here.
Great to be here.
Looking forward to the discussion. I was going to say it's a timely one, but it's always timely. And I guess that's my perspective as an employment lawyer. We're almost always talking about some degree of layoffs or downsizing. Then it could be one, it could be 10,000. And unfortunately, if you believe the predictions for 2023, it sounds like we might be seeing some more large-scale downsizings. We've already seen a few, especially in the tech world. But I wanted to talk a bit about some do's and don'ts. So before we get to that, though, Brian and Frank, why don't you quickly introduce yourselves and let the viewers know what it is that you do?
Great. Thanks very much. So my name is Frank Newman, and I've been working in HR for 47 years now. And I've seen just about everything in the workplace, from voodoo to love triangles. I've opened plants. I've had to close plants. And so I've seen just about everything in HR. And so I'm delighted to be with you today to share some insights into some of the experience that I've had.
Thanks, Frank. And hopefully we're going to get back to the voodoo at some point, because I do want to hear about that. Brian, why don't you go ahead?
Hi, my name is Brian Epstein, and I'm a career consultant, and I've been helping human resource organizations and companies for over 20 years, helping the people who are making some restructuring in their organizations and supporting the employees or leaders and management as they've left the organizations, and ensuring that they are okay and can move on to their next roles in a timely manner.
So, well, thank you again, both of you, for being here. And so let's get right to it. And I know, one of the first things we want to talk about is there such a thing as a good layoff or termination? So, Frank, do you want to take that one first?
Sure. Yeah. So in terms of, is there a good or a bad layoff? Generally, for obviously for the individuals concerned, it can be a traumatic experience. So generally, if you're sitting on the opposite side of the table, it's not a good news experience. However, on the other hand, there are better ways of doing it so that you treat people with respect and dignity. And the irony is, I found in most cases where people have been let go, they eventually wind up getting a better job or are more satisfied with their next role. Because when you're being let go, there may be issues there may be concerns with the company or your individual performance. So, I've been on the receiving side of the table 3 times, and each time I've grown and gone on to better jobs. So, but there are better ways of doing it, and I could share some my own personal experiences on that too.
Sure, that'd be great. And yeah, I mean, I share your view, Frank, and I've often had that experience where I've had someone come in to meet with me after they've been let go. And yeah, in some cases, people just know it's just, part of the job, so to speak, par for the course. But sometimes people are just devastated and they don't know where they're going to go, how they're going to replace the income, how they're going to support their family. But like you said, in most cases, it often ends up being a blessing, and they move on to something bigger or better. In many cases, I've had clients who always wanted to go into business for themselves, but they were too scared to leave the secure job they had. So this forced them to do it, and it's been quite successful. So I know it's often not well received in the course of that termination meeting, but you obviously, as you said, you're trying to make it as positive as you can. Brian, I guess I'll turn it over to you. I mean, if in terms of making the termination experience as good as possible, I mean, what should some of the goals that you're aiming for be in that context?
I think it's really important to always be concerned about how the employee is going to react. What are some of the issues that are at hand? And also putting yourself in that position. If you're a human resources person that's about to have to do with downsizing in the organization, try to place yourself on the other side as you run through the scenario that you're going to go through that day. And I think if you keep that in mind the whole time, it could make things a little bit more smoothly. I'm also obviously brought in as a buffer when the person receives the news. I'm there to support them afterwards, and I think that to have a buffer is really important. But keeping in mind whatever you can do to make the person feel respected and to feel that he or she is given the best support that he or she can when he or she receives the news.
I'll ask a question somewhat facetiously, because I fully agree with what you said, Brian. But why do you care how the person receiving the news is going to take it and how they're going to feel?
Well, I think you'd like to live in a world where people treat everybody with respect, a little bit more kindness, a little bit more empathy. I think that's really, really important. It's also good for the organization, the word of mouth that's going to go on afterwards. If it's not done in such a good way, the person that's laid off or has given the notice, he or she's going to probably go and say some very bad words, or he could react in a way that you don't want him to react in. So it's always trying to mitigate the risk, and that's what we're trying to do when we're trying to support the person the best way possible.
Yeah, the other point I was going to add is that the concept is ideally if people have to leave an organization, you'd like them to leave as positive ambassadors for the situation. And again, you don't know how people are going to react, but you certainly know that they're going to go home and they're going to tell their wives, their family, they're going to post something on Facebook. And so to the extent you can provide a clear message to make sure it's concise, to treat them with dignity, they're going to remember that, because quite frankly, this is the most painful 2 or 3 minutes in your life. And hearing the news that you've lost a job is devastating for your self-worth, your impact. And so somehow you have to step back, as Brian says, and make sure that you're thinking about what's the big picture. The big picture is we might need them to refer someone to us in the future, or we might want them to say other things at an industry conference, because we also know that everybody has a long memory. And if we have a bad experience, we're going to tell 10 people. If we have a good experience, we'll tell one.
And if I could add on to that just for a second, it's not only you and your family, but it's the people that are left behind after you leave an organization. So the word gets back to the rest of the people at the organization, just what happened to the person that was let go. And that could create stress, or it could create more calmness, depending. I mean, there's obviously going to be some questions, why did it happen? But if it's done in a respectful and fair way, the other people, or we might call them the survivors, will feel, they treated the person the best way they possibly could given the situation.
And I think that's a really important point. So thanks, Brian. And like you said, I mean, and I like the way you started off, Brian, by saying this is just the right thing to do. We should treat people with respect. But then, of course, there's also a business reason for it. Like you said, Frank, you want them to be ambassadors. You want morale among the survivors to be good. And of course, from the legal perspective, if you really treat people badly in the context of a termination, you can be on the hook for additional damages. So there's a legal reason as well. But I wanted to get back to your last point, Brian, about supporting the quote unquote survivors, because we've seen, especially through recessions, through the pandemic, we've seen situations where you have a mass downsizing, maybe a third or a half of the people are let go, but then those who remain are now doing 2 or 3 jobs for the price of one, so to speak. So that's one of the issues. But I wanted to ask both of you, what the best way is to manage the aftermath amongst the remaining staff and make sure that morale is not negatively impacted by the downsizing.
Yeah, typically one of the things we always do is as we're planning a termination, we also plan for the post-termination communication. So we make sure that people hear about it in the right manner, in the right sequence. So dealing with the immediate people in their team first, and then determining how to share that broadly. I also coach managers to make sure you're not saying negative things about the person that left. that's a private matter. And so you need to respect the dignity of the individual. And as has been said before, people are watching to see, well, maybe I'm next, and how will they treat me, and will they badmouth me? But boy, it's hard to stop managers from saying bad things if they just let someone go. So there has to be a sense of restraint with that if you're going to have any communications at all.
Yeah, it's a great point. That's something that we really coach our clients on as well, because again, I mentioned potential for additional damages. I mean, if you've let someone go and maybe they're contemplating a wrongful dismissal claim, and maybe it's just a money issue, maybe they think they were entitled to more severance, but all of a sudden they start to hear from their friends or so the company that their manager is bad mouthing them, then all of a sudden it becomes a bad faith claim or a mental distress claim. So in addition to it being the right thing, and for business reasons, you don't want to expose your company to more liabilities. I think that's a really important point. I was going to jump back. I mean, in terms of bad faith claims, I mean, by way of legal history, and I've probably talked about this before on the show. I mean, we have since 1997, there is a legal principle that employers have a duty to act in good faith in the course of termination, and that was in the Wallace case. And so, as Brian and Frank, you guys will remember, we had about a decade where every single claim contained a plea for Wallace damages. Everything was bad faith. If you let somebody go on a Friday, you ruined their weekend. If you let them go on a Monday, you ruined their week. If it was the month of their anniversary, you ruined their anniversary. If it was the month of their birthday, you ruined their birthday. It got to be the point where I used to joke and say you had about 1 hour a year where you could safely let somebody go. And unfortunately, our Supreme Court of Canada in Honda and Key sort of reined that in and said bad faith actually has a meaning. It's got to be real bad faith. But we still hear all the myths about what you can and can't do. You should never fire somebody on a Friday. You should never fire them on a Monday. So I'd love to get your comments on the when and where and how you approach that.
Yeah, that question comes up often. And typically, yeah, I try to avoid Mondays because typically managers aren't prepared to have a tough conversation on a Monday. Fridays I discourage because they can't get a hold of their colleagues. So typically I'm looking at Wednesday, and I guess it became too well known that I terminated people on Wednesday because one of my clients, they used to call it Axe Wednesday. So we did get out of that. But certainly, the other thing I find is a lot of employers are trying to say, well, should I terminate somebody in December? And so in the past, we would say, no, nobody should be terminated in December. However, I think now it's reaching into the first week in December. But apart from that, I typically say no. But then recognizing too, we've got a lot of people who are not necessarily celebrating Christmas. But I think that's a general rule of thumb that I've seen. You really don't want to ruin somebody's Christmas or New Year. So guess what? I've done 4 terminations in January already. So.
Now, I noticed an uptick in the number of terminations that we've seen in December over the last couple of years. Have you noticed that as well?
I've certainly seen more incidents of it. I think people are desperate to let people go, and so they don't want to wait till January and pay them for the Christmas holidays. But I typically say better to wait till January, start the new year fresh.
Right. Now, it was interesting what you were saying about not doing it on a Friday. One of the theories I've heard that made some sense to me was if you let somebody go on a Friday, it gives them the weekend to calm down. So instead of them racing off to a lawyer that afternoon or the next day, they've got a couple of days to calm down. And it resonates with me because, and I may have shared this story with one or both of you. There have been a couple of times in my career where I have taken meetings with people who literally called my office on the way home from the termination meeting. And I've sworn I'll never do it again because they came to my office. They were so upset that they could not possibly see things objectively or reasonably. And it was a complete waste of time because whatever we decided had to be revisited a few days later when they calmed down. So I always, when people call our office now, we always try to build in at least a few days before we meet with them. And so I was curious about your thoughts on whether that would be an advantage to letting someone go on a Friday because it gives them the weekend to calm down.
I can see it from your perspective that you want them to calm down because when they see you, Stuart, you want them to be in a calmer way. And so I can see why it would be good to have it on Friday just before the weekend, so they'll calm down to see you on a Monday. On the other side, though, my thoughts have always been to if the person could be told on a Tuesday or Wednesday, they have enough time to whether or not they want to see a counselor, a doctor, they want to, they're feeling anxiety, they want to look into their employment insurance, they want to go call their financial planner or their banker so that they can get this, they know where they are, and that might alleviate some of the anxiety they may be feeling.
Fair point. I appreciate that, Brian. So another thing that's become more of an issue in the last couple of years is terminations by Zoom. There was a time where I think both of you guys would have just immediately shook your head and said no. But what are your thoughts now?
Great question. Certainly, we're doing more and more things by Zoom. I mean, we're hiring people by Zoom. And so certainly I've seen many more terminations by Zoom. And to some extent, it's almost better for the individual because when you have a face-to-face meeting, there is certainly more animosity, more emotions experience there. And for most discussions, it's a 3 or 4 minute discussion, basically delivering the news. So it's less painful to do it by Zoom, to be honest. It does prevent them from going and talking to their buddies or saying goodbye to folks. But on the other hand, it ends it much quicker, and you've got more opportunity to kind of reflect personally. And probably it's a little bit less emotional because it's sort of like watching TV. One of the worst cases I had when I was being let go is they had me drive all the way into the office for a 2-hour commute, and then gave me the news. So I would have preferred Zoom.
Yeah, I heard one even worse recently where somebody worked in Toronto but head office was in Pittsburgh, and they made them actually fly to Pittsburgh and stay overnight and come in the morning, and at 9:15 let them go, and they had to go home. And I remember he came into our office and said, "Why didn't they just call me? Why didn't they just do a Zoom?" But the interesting thing is it came out that the manager had been told for probably more than a decade that you never do a termination meeting by Zoom. You always do it in person. So they were just following the prevailing wisdom up until at least fairly recently. So there were good intentions there, but certainly not well received.
I just want to share, just recently, there was an organization that was doing a downsizing, and I was involved in it. And the organization, the HR people, didn't even know if the person was going to come in. So they didn't even know if they were going to do it on Zoom or they were going to do it on person. So it was going back and forth. They were trying to make the right plans. Do we set this meeting up? Do we put Brian in over here, or do we from a logistic point of view, it was a challenge because people are working from home and they're coming into the office at different times these days.
Yeah, no, I think we've got to be a lot more flexible, but at least, I always encourage our clients, whether, and this is a good segue, actually, the next thing I wanted to mention. I always encourage our clients to think about what the options are and not do it the same way every time. It's not a one size fits all type of approach. And where I was going with this was the other issue is working notice versus providing a severance package. And I shared with you guys offline or off screen, I guess, 2 recent cases I dealt with, the exact opposite approach. In one case, the person had been given working notice and they were really, really angry that they were being forced to work instead of getting the package they should have been receiving. On the flip side, you had someone who had been given a package and was quite upset because she wasn't given the chance to work through the notice period, where in her mind, it's much easier to find new work if you have work. So that opportunity was taken away from her. So both people were equally upset, although they were treated in exactly the opposite manner. But I'd love to get your thoughts on use of working notice and also just when it's appropriate to give the employee some choice as to how you proceed in that context.
Yeah, I've had some experiences recently with working notice, and generally most people now, if they're going to be terminated, they're actually expecting a package. So the first response I get with working notice is surprise. Say, well, where's my money? And so that's just really what upsets them, because they're thinking there's a cash grab or something at the end of it. On the other hand, if you do have working notice, you also have the possibility of somebody poisoning the environment in terms of their morale, their disengagement, and you really have to question how much actually work is going to get done. Whereas to some extent, it's much cleaner once they leave the office. But I have had people that have wanted to stay at their desk and finish a project before they leave. And so I think you've got to assess the conscientiousness and the relationship of the individual as you're trying to make that decision.
And on top of that, some people want to walk out the door right away, and some people want to work for a foreseeable future. So, given everything that Frank said, that you got to assess the situation. It may, if possible, to sit down with the actual employee, and assuming that his morale and he's not going to cause any kind of negativity to the organization, and it can be arranged maybe for him to stay for a couple of days or a few days or a little while, may be a good thing to do if possible.
Yeah, and I think that's a perfect approach. And it's, again, it's not a one size fits all. It will depend on the nature of the relationship and the individual. But it's worth giving that some thought and having the discussion. And it was interesting. I know, Frank, to your point about working notice, I mean, I've seen it work very well in some cases. And often where I see it be successful is where either the department or the organization as a whole is winding down. I'll give you an example. I had worked with an accountant a couple of years ago, and he had a practice. He had about 5 lawyers, about 5 or 6 staff, and he was in his 70s. He was going to retire, so he wanted to wind it down. And so the messaging was, it's not you. It's we are winding down the practice, but I need you to stick around and help me look after all of our clients and make sure everything gets done. So if you stick around, I think in that case, he asked them to stick around for a year. But at the end of the working notice period, assuming the people didn't leave, then they got a payout. So you don't have to do working notice or severance. You can combine the two. So if the person's entitlement is 15 months, you could do 8 and 7, or whatever division you like. But there's lots of options. Again, I just encourage everyone to consider the options and not do every single termination the same way. So, sorry, Frank, you want to add to that?
Yeah, I think you're absolutely right, Stuart. Having a hybrid approach is really very clever because it can balance both the need to keep some work done, keep somebody employed while they look for another job, and knowing there's a cash incentive at the end. And certainly I've done that when we've done major plant shutdowns where we told people in advance, but there was still a package. And during those times, we never lost a minute of productivity. We had higher productivity because people knew they were being treated well and fairly.
No, thanks. And that's a great point. And so, as I warned you at the beginning, the time does fly by. I wanted to ask one more quick question before I take my chance to fire away. But this is something that often comes up, and as you were talking, I thought of it. Are you still seeing situations where someone is let go, they've got a company phone, and they say, "Well, wait a minute, all of my family photos, all of my personal stuff's on that phone. You got to give me a chance to get it off." Are you still seeing that? And if so, how are you advising companies to handle that?
I have seen that, and I continue to see that. And depending upon the organization, they will say, okay, maybe we'll deal with that another day. Maybe you can come back to the office, or when other people are not working here, and we can do it at that time. You can download all the pictures you want and everything you want at that time. Or they may do it at that, they may give 10, 15 minutes or a little bit of time on the day of the transition, as long as somebody is with them. I'd be interested to see, Frank, what advice, suggestions you have about that.
Yeah, I've seen similar cases. I've had people say my whole life is on the company computer, and I had no holds barred. I put all my pornography on there. Everything is on there, and so clearly they want it back. And so we've had the IT people sit down and go through it and send them an edited version. But it is amazing how people just forget that these are not their computers, and so they continue to fill them up with the most inappropriate or sensitive documents.
Yeah, well, just on that point, and I don't want to digress too far because I know we're already about 24 minutes in, but I've seen that situation where someone's let go on a without cause basis. It's a downsizing. But when they hand their computer back, you realize all of the materials that they have downloaded, all of the things they've been doing while they're supposed to be working, and all of a sudden it becomes a just cause case. And when the evidence is there because they put it there themselves, it's pretty hard to argue with. So that's something else people should be mindful of, which, again, you kind of suggested this, you should not be using your work computer as your personal computer for that reason.
Yeah, particularly when computers are so cheap these days, but people get used to it. Yeah.
Exactly. All right. Well, we'll end it there. But Brian, Frank, thank you guys so much for joining me. It was a great conversation. I really, really appreciate your time.
Thank you. It's our pleasure.
Thank you. It was great to be here. I appreciate it, Stuart.
All right. Well, now I will take my turn to fire away. All Right, what I want to talk about today is really encourage people to be very cautious about recording their interactions at work. Now, the irony here is we always tell our clients that legal battles are not decided based upon truth, they're decided based upon evidence. So the question is not what happened, it's what can you prove? And sometimes we have the traditional he said, she said, particularly for incidents of harassment or sexual harassment where there's nothing in writing, there are no witnesses, and the victim may really have no other option but to record incidents. So sometimes it's a good idea. In a time, though, when everybody's walking around with a camera, video, and audio recorder in their pocket, it's really easy to do. And perhaps sometimes it's too easy because it's tempting to record conversations when you really shouldn't. So I'm going to talk quickly about two recent cases, both of which involved employees who recorded conversations at work. The first was known as Shaligan and Mercer Seelger, out of British Columbia. And in that case, Mr. Shaligan was initially dismissed on a without cause basis. After he was fired, he sort of attacked on all fronts. He brought a human rights complaint, an employment standards complaint, and a civil claim. He alleged he'd been terminated as a reprisal for raising concerns about his bonus, and the company had been dishonest about his bonus. During the discovery process, which during a civil court action, there's a discovery process where you have to disclose all relevant documents in your possession, which includes recordings. So Mr. Shaligan had to disclose the fact that he had made hundreds of secret recordings of conversations with other employees, both one-on-one and in group meetings, and included everything from business meetings to discussions about family issues with colleagues. And all these were in the recordings. And Mr. Shaligan didn't offer a particularly compelling explanation for why he did this. At one point, he tried to say that it was to help him learn English. That's why he recorded the conversations. I don't think the court was particularly persuaded by that. So I'll stop for a second and just mention that contrary to popular belief, it's not illegal to record a conversation in Canada. And I think it's different in the States. In Canada, as long as one party to the conversation consents, then it is lawful. It's not unlawful. And that party can be you. So if I'm talking to Brian, I can record the conversation even without telling him. But what I can't do is start the recorder and then leave it in the room with Brian and Frank and listen to what they have to say. That would be unlawful. But in the Shaligan case, the judge noted that legality is not the sole barometer. The question is whether the employee's actions fundamentally ruptured the relationship. And in that case, the court was not particularly convinced that there was any reason to record these hundreds of conversations, and in fact found that he had irreparably damaged the relationship by doing that, which of course is a test for just cause for dismissal. So the irony, of course, is he tried to use the recordings to bolster his case. They ended up completely torpedoing his case. On the flip side, we've got the case of Rooney and GSL Chevrolet Cadillac. As a Ferris Bueller fan, I love the fact that the plaintiff's name was Edward Rooney. But in this case, he was successful because he was let go. He believed he was, before he was let go, he thought he was being unfairly disciplined for various conduct. So he recorded conversations with his supervisor. The company alleged that those recordings had ruptured the relationship and was after acquired cause. Court didn't agree with the company. The court found that by the time he was recording them, his employer had suspended him without pay, and he had reason to be concerned that he was being portrayed as a problem, and that he had good reason to start recording these incidents to basically defend himself. Even in that case, though, what the judge said was that recording conversations in the workplace will often cause irreparable damage to the relationship of trust between the employee and the employer and be just cause for termination. So in that case, Mr. Rooney was successful, but the judge did note that in many cases, if you record conversations at work, you're actually not helping yourself, you're hurting yourself. So the bottom line here, just because you can easily record interactions at work doesn't mean that you should. And you need to remember that if you commence a legal action, you are going to be required to disclose all relevant documents, including recordings. So even if you make a recording and your lawyer tells you that it's not going to help, in fact, it's going to hurt, you can't just hide it. You're going to have to disclose it. So be very, very cautious about recording, even though it is very easy to do. That's all for today. That's also a wrap for season 5, episode 12 of Fire Away. So I want to thank everyone for tuning in, and a very big thank you to Frank Newman and Brian Epstein for being my guests for a great discussion. Reminder that past episodes can be found on YouTube, on our website, and on Facebook. If you like our page, or subscribe to our YouTube channel. You'll get notifications when episodes are live. Our next episode is going to be on February 21st. We'll be joined by Shawnee Love and Carlos Cadogan for a discussion on how to respond to harassment complaints. And this, of course, is deliberately timed to be a week after Valentine's Day. So it should be a very interesting discussion. I want to remind everyone that at Rudner Law, we want you to treat your employment relationships as legal relationships and to make informed decisions rather than assumptions. So I'll invite you to check out all of our social media, including Twitter, Instagram, LinkedIn, and Facebook. Subscribe to our YouTube channel and subscribe to our newsletter. But as we always say, none of that replaces legal advice tailored to your particular circumstances. So if you think you might need an employment lawyer, you probably do. Feel free to reach out to us. Thank you to Rob, to Mark, and Rebecca for getting the show to look as good as it always does. Thank you for tuning in. See you next time.